Good afternoon, sir. Can you see and hear us?
Yes, thank you.
Good afternoon, Mr. Williams. Can we go back to an issue that we addressed this morning, which was your advice on communications with Tim McCormac, and you asked whether it would be possible to see a letter that you wrote. I think I've tracked that down.
Oh, thank you.
It's poll 0011-8066. Can you see this is a final version of a letter that was sent to Mr. McCormac? At the foot of the page, we'll see that it was sent by you. And at the top of the page, we'll see it's the 19th of November 2015. And if you just quickly scan the paragraphs to see whether it's the letter to which you were referring.
I think it is, thank you.
It is the letter. And so was the point that you were making that in this letter, by this letter, you had asked Mr. McCormac to provide you with evidence?
Yes.
Thank you very much. So in relation to some questions that you asked Mr. Williams, that can come down, that you asked Mr. Williams earlier about the post-trial pre-judgment exchange of correspondence over the 14,000 new kells. There is some material which touches upon that. I'll address that, if I may, tomorrow morning with Mr. Williams, so that we've got the complete set of correspondence on the system.
Thank you.
Can we turn to the provision, therefore, Mr. Williams, of material to second sight? Can we turn up page 14 of your witness statement, paragraph 30, please? And can you see in paragraph 30, you say second sight had been appointed before you joined the post office and you didn't have any direct knowledge of the process or how the scope of its original retainer was determined. And then 3 or 4 lines on, you say, I felt I needed to raise the risks around disclosing legally privileged documents to a third party without putting a clear framework in place to govern their use.
Yeah.
And then if we go to paragraph 34 on page 16, please. You say you review remembering a number of drafts of spot reviews to see what they look like, sharing thoughts with Womble Bond Dickinson. And then a couple of lines on, I recall that the post office sought to organise the preparation and drafting of the spot reviews in a way that would maximise the potential for the post office to claim legal professional privilege over them and any exchanges with Fujitsu relating to them as they were being developed. Was that essentially a strategy that would apply in ordinary litigation?
I would think so. When it's contemplated, you're usually keen to understand what's an issue before, so that you can take informed advice on it before proceeding to take your actions.
And were you comfortable in cross-applying that approach to the second sight initial investigation?
I think there are 2 bits there. Part of it was also so that the company could obtain advice on what was being revealed through the investigations. So I think that the privilege and issue wasn't just in connection with, say, contemplated litigation, but also so that advice on what it may mean for post office's legal position could be obtained as material was identified.
Was
or
any...
created.
I'm sorry.
I beg
Was
your
any consideration given to the fact that you were not in litigation at this time, but you were in a sort of quasi-mediation process?
My recollection is that the prospect of litigation was sort of always sitting there. Looking at it today, I'm not sure whether it would be properly contemplated for the purposes of litigation privilege, but at the time it felt like a claim was always around the corner.
And that can come down. Was any consideration given to the fact that your company was government-owned, and in many of the functions it discharges them, or they are functions of a public nature?
That was a consideration that came up a lot. Was Paul a public body?
You called it a public body there. Was that a factor that was brought consciously into account in the course of either the first part of Second Sight's activities or when you entered the mediation scheme proper?
I don't recall it. I'm thinking it's more. Sorry, let me. Sorry, could you have another go at the question? I think I know where you're at, but I'd like to make sure I understand the question.
Was any consideration given to the fact that your company was government-owned and many of its functions were those of a public nature? You called it a public body. In either the initial activities of Second Sight or when you entered the mediation proper?
Yes, it was. Now, I'm sorry, and thank you for. I appreciate that. I think they're a little bit. I remember it being an issue largely because of questions around whether, from so far as my role was concerned, whether post office's actions may be amenable to judicial review was certainly part of that consideration. And I think there was also consideration that post office is amenable is open to Freedom of Information Act requests as effectively a designated body fit for that act.
Both of those answers, Mr. Williams, are essentially technical legal answers as to the status of the post office and the application of either public law or the Freedom of Information Act to it. My question was, in the context of either the initial work by Second Sight or in the mediation proper, was consideration given to your status as a public body as you've described it, in terms of how should we approach these things?
I don't think so. I think the not terribly far removed from that maybe was the concern that post offices in every community throughout the length of the breadth of the country. That was post office's status in those communities was, I think, part of it. But that and we were also aware of very considerable stakeholder interest from members of Parliament who were considered, I think they're quite often referred to as a stakeholder group, but I don't recall anything other than that. But that may be because I just wasn't in my bailiwick.
It's sometimes said that public authorities, public bodies, or organisations who discharge functions of a public nature should operate by different standards in litigation or quasi-litigation like a mediation. Was that something that was ever discussed within the legal team, so far as you're aware?
I don't recall that, no.
Was it ever discussed between you as the lawyers and executives as the client?
I don't recall that.
I hold on, we're a public body here. Some might say that we've got different duties and standards to adhere to and apply. We're not just another big corporation who's free to litigate in any manner we choose?
Not in those terms, but there was the sense that, Post Office. I do think there was a sense the Post Office, because we were in communities, length and breadth of the nation, that it was important to be doing the right thing. I think that's probably the way to describe it. I think there was a concern for that to be done. I don't recall it in the sort of construct of the public body that you've been describing.
I think it's fair to say in the 130 odd pages of your witness statement, we don't see the considerations that I've just raised reflected. That's right, isn't it?
That's correct, yes.
And in any of the documents, I don't think we see those considerations reflected, do we? Certainly the ones you've seen.
No, we don't. I don't think so, no.
Was that a concept with which you were familiar at the time? Public authorities may have to behave differently when they come into contact with the law than private companies.
No, that's not a concept I'm familiar with, I'm sorry.
Would it be fair to say that in your legal advice and any discussions you had with clients, you regarded the Post Office as any other litigant? It could be a big city corporation.
No. I don't think we could act in the way Big Oil would act.
So I missed that word, big.
Sorry, Big Oil, for instance, like a large petrochemical company. No, I think there was.
Why not?
Because there was a sense that. I think Post Office is concerned about its image. It's in communities. It's part of the fabric of society, and as a consequence, it couldn't be a plough on, be damned.
Okay, we'll move on. Can we turn to page 17 of your witness statement and paragraph 36? Page 17, paragraph 36. You say the inquiry has asked me to comment on a draft email addressed to John Scott, the Post Office Head of Security, and Rob King, the Post Office Senior Security Manager, and that's Mr. Scott's deputy, which was sent to me and Simon Baker on the 13th of May 2013 by Dave Posnett, an accredited financial investigator. It contains a series of bullet points, updates on the spot review process. It appears from the email that I'd asked for draft responses to be sent to me for forward transmission to Messrs. Scott and King. I believe I requested this for two reasons. First, part of my role was sometimes to review and or distill information provided by one part of the business comprehensively for other parts of the business, so there was a consistent joined-up position. Second, if the emails contained legal advice or concerned matters on which legal advice would be required, then the Post Office would be better placed to claim legal professional privilege over the material if it had been sent to or received by a legal advisor. Do you agree that Post Office could not claim privilege over communications simply because they were sent by or to a lawyer?
Yes. You cannot claim privilege just because it's sent to a lawyer.
Were you, by adopting this approach, routing emails like this through you, seeking to protect the communications in that way by making a claim of privilege available to you?
Yes, if the claim was available. If the communication was for the purposes of obtaining advice, or advice sort of flowed from it, it raised issue. It's my recollection at this time was information was being created and generated that some of it was new to Post Office, and it was certainly newly created, for instance, the spot reviews. And it wanted, I think, to understand what that was, take advice as appropriate on it, before it entered the public domain, where its ability to address the information would be harder to manage.
Can we look, please, at poll 0014-2323? I'm afraid I haven't got the tab number for that.
We'll have it on the screen, that's fine.
Poll 0014-2323, thank you. It's a one-page email from Mr. Scott to, amongst others, you. You can see the distribution list at the top. Okay. And the subject is the protection of commercially sensitive and or legally privileged information. And Mr. Scott says a review has been conducted in respect of commercially sensitive and or legally privileged information, in particular the management of exchange of information subject to the second site review. While most information within this group will be legally privileged, nonetheless, if the information was to inadvertently be sent to the wrong email address or intercepted innocently or otherwise, once out in the public domain, it will be hard to control. Having agreed with Susan Crichton with immediate effect, all information should, where possible, be placed onto a document, and access is through a password protocol. The procedure is easy to use and only takes a matter of seconds. And then there's some administrative details, and then additionally, commercially sensitive and or legally privileged information should not be copied or pasted onto unprotected email text to make it more easily readable on a BlackBerry. Why was a review conducted in mid-2013 of the management of an exchange of information with Second Sight?
I'm sorry? I'm sorry, it was a bit too quick. I didn't.
Yes. Why was a review conducted in mid-2013 into the management of an exchange of information with Second Sight?
I don't know what triggered that.
Can you recall?
Sorry, could I see the date of this?
Yeah, it's July.
Oh, sorry. Sorry. Now I see the date. I imagine that this, I don't know about the review, but there was certainly an issue with potential shredding reported shredding or suggestion to shred, however you want to describe it, of documents, I think in July, around this time. I might need some help with the date, but it certainly feels contemporaneous to this.
Do you think this review into the management and exchange of information subject to the Second Sight review was therefore triggered by the allegation that some minutes of a meeting either had been shredded or were ordered to be shredded?
Sorry, I think there are two parts there. I'm not aware of a review in the sense of we had quite a few sort of quite formal reviews. I'm not aware of including say of the past prosecutions that was about to commence at this time. So I'm not quite sure about that. But I think that I suspect the catalyst for this will have been what you described. I'm not sure about the format. Does that make sense?
Do you know who conducted the review?
Well, that's what I say. I'm not really familiar with the concept of a review here.
Mr. Scott was somebody whose department was under scrutiny in the course of the review, wasn't it? The Second Sight review.
Yes, yes. I think security files were being provided. Yes, I think that's correct. Yeah.
i.e. the way that investigators had conducted themselves was something that some complainants had raised.
I don't know whether I was aware of that at the time, but I think that's correct, yes.
Do you know whether Mr. Scott conducted the review of commercially sensitive and legally privileged information?
As I say, I'm not familiar with the review, so I don't know who may or may not have carried it out.
Can I turn then to the second site interim report of the 8th of July 2013? I think it's right, you know, that report, sorry, that can come down from the screen, referred to 3 bugs in Horizon: the receipts and payments mismatch bug, the suspense account bug, and the calendar square, sometimes called Falkirk bug.
Yes.
And you know, I think, that Simon Clarke's advice of the 15th of July was written in response to, amongst other things, that interim report.
Can I say, I'm afraid I get Mr. Clarke's advices confused. Can I be taken to the 15th?
Yeah, we can look at the first advice if you want to. It's the 15th of July advice, poll 3 zeros 4, 4 zeros. That's B65 if you want to look at it.
Pardon. 65, was that?
So we've got the second site interim report picking up the 3 bugs
Correct.
of the 8th of July 2013. And then this, 7 days later.
Yes.
We can see, if we go to the last page, which is page 14, the date of the...
Thank you.
Just let it come up on the screen, thank you. The date of Mr. Clarke's advice. If we go back to page 1, it's an advice on the use of expert evidence relating to the integrity of the Fujitsu Services Horizon system. The inquiry is very familiar with this, so I'm not going to go through it at length, instead take you to some parts of it. Can we go to page 10, please? And paragraph 28. Mr. Clarke says, in considering this report, that's the second site report, I only take account of those matters indicating a prior knowledge of Horizon issues. And then he says the following paragraphs appear relevant, and then he cuts in extracts from the second site report. At his, or at their 6.5, the first defect, that's the receipts and payments mismatch bug. And then at 6.6, the second defect, that's the local suspense account bug. He doesn't, in fact, mention Mr. Clarke here, the fact that second site had been told about and picked up the calendar square and Falkirk bug. And then he continues at 29. On Thursday, the 27th of June, Martin Smith of Cartwright King was telephoned by the post office. There then ensued a number of conversations between Martin Smith and senior post office executives. The import of what Martin Smith was being told may be summarised thus. He was informed by post office that a report commissioned by Second Sight by post office and as yet unpublished indicated that Horizon may not be bug-free. There was much speculation as to the content of the Second Sight report. It appeared to the post office that some within the organisation had been aware of bugs affecting up to 30 offices, including some Crown Office branches. Jarnail Singh, head of criminal litigation, had been unaware and did not know how long post office had known of the existence of the bugs, nor indeed who at the post office had known. And so we've got Mr. Clarke recording here that Mr. Singh, on being told of the possible conclusions of Second Sight as to bugs, said that he had been unaware and didn't know for how long the Post Office had known of the existence of the bugs, nor indeed was he aware who at the Post Office had known. Yes?
That's what it says, yes, I can see that.
Keeping this in mind, in paragraph 46 of your witness statement, I'm not going to ask for it to be turned up at the moment, you tell us that in relation to these 3 bugs, that prior to publication of the interim report, your role was to collate and distill information for the use of others, considering the Post Office's response to the interim report.
Yes.
Yes?
Yes.
Can you please help us? Before the Second Sight report, had Mr. Singh ever informed you that in fact he had been the prosecutor in the case against Seema Misra?
I don't know about that particular status, but I remember seeing an email exchange where, when I was asked to, I think we referred to it this morning, I was asked to see if I contacted Bond Dickinson and GAC Beechcroft to see if bugs had been referred to in any cases. And I saw that John L. seemed to have known about that, the Misra case and that, but I don't recall it.
I'm asking specifically about whether before the Second Sight report, Mr. Singh had ever told you that he was in fact the prosecutor in the case of Seema Misra.
I don't recall that, no.
Did he, before the Second Sight report, tell you that, having been the prosecutor in the Seema Misra case, that he had been told about the Calendar Square or Falkirk bug?
I don't recall that.
Back in 2010?
Yeah, I don't recall that being said, no.
That he had been told about a locking issue in Horizon that had caused transactions to be lost?
I don't recall that, no.
Did he tell you before or at this time that he had been told back in 2010 that there were some 200,000 system faults recorded in relation to Horizon?
I don't recall that, no.
Did he tell you that part of the work that Fujitsu had undertaken in the prosecution of Seema Misra was to provide an estimate of what would be involved in providing the defence with all change requests made at the Horizon counter, but that the Post Office had decided not to go through with that work?
I'm not aware of that, no.
Did Mr. Singh tell you at this time or before this time that both he and Rob Wilson, the then head of criminal law, had been personally informed about the receipts and payments mismatch bug back in 2010?
I don't recall that, no.
That they had been engaged in discussions and conferences as to whether or not to disclose that information about the payments and mismatch bug to Seema Misra's defence team?
No, I don't recall that.
And that a decision had been made not to give disclosure?
I'm not aware of that. No.
If we can turn up at paragraph 46 of your witness statement, please. Paragraph 46. At the foot of page 23. You say you've been asked to comment by us on your knowledge in mid-2013 of the local suspense bug. I've been referred to some emails mentioning it from around the same time as those relating to the Calendar Square bug. I believe the post office brought the local suspense bug along with the receipts payments mismatch bug to Second Sight's attention. The context over the page in which I came to deal with these bugs was the same as I've described above, and my role was again to collate and distill information. Was there any sense at this time, mid-2013, around the time of the publication of the Second Sight report, that the post office was essentially saying this information about the 3 bugs is newly acquired information by post office?
I'm pausing to answer because it seemed to be new to some people within POL, hence the request to try and find the information, package it up and present it to people. But by the same token, we seem to be able to get answers to it.
That can come down from the screen, thank you. Are you saying that when the interim report came out and these 3 bugs were mentioned, that was news to some people within post office, but not to everyone?
It was certainly news to some people, and what I don't know is having been able to find people within the business with some understanding of it. I don't think I ever found out whether they'd started that inquiry at the same time I had or had prior knowledge of it. So it was certainly new to some people.
Did you seek to ascertain when the post office had first become aware of those 3 bugs?
I think that came out with some of the. I didn't proactively seek to find that out. I just tried to find out what we knew, and through that, it was clear that. I think somewhere in there's a date that says we've known about this since. I did a timeline where I think it was amended to include a date, but that wasn't a line of inquiry. It was more that a consequence of my request for.
Wasn't that line of inquiry an important one to ascertain when the post office had first become aware of those 3 bugs?
Yeah, probably. Yeah, I would say.
Would you go as far as definitely?
Yes.
I mean, if I give you an example, wasn't that information critical to determining which prosecutions might be tainted if full disclosure of the existence of those bugs had not been given?
I have to say, questions like that I wasn't aware of at that time. I had no idea what the impact on prosecutions might have been when I was being asked to find information about the bugs.
Wasn't that information that was of prime relevance to which, if any, sub-postmasters' contracts may have been wrongly terminated?
Possibly. It depends on the basis for termination, I think.
Wasn't that information, i.e. when did we in Post Office know about the existence of these 3 bugs, relevant to the issue of which, if any, of Mr. Jenkins' evidence may have been tainted?
That's a criminal law matter, so I can't give a view on that, I'm afraid.
To your knowledge, did anyone seek to ascertain which departments or which individuals within such departments knew about the existence of those 3 bugs?
I'm not aware of that, no.
Do you know why not?
I'm sorry, I don't.
We've got this report that says there were these 3 bugs. When did we, Post Office, first know about them? And how does that affect the proceedings that we've brought against people, whether civil or criminal? And how does it affect contracts that have been terminated?
Well, I think there are 2 parts to that question. So the first bit is when did we first know about that? Well, that seemed to be coming out from the request for information about the bugs. The use of that is a segment. Was it important to find out? Well, I think it was being found out from what I could see. Somebody said, well, we first knew about it on this date, we told Fujitsu about it on that date. That's with respect to one of the two bugs. I can't remember whether we did it for both. What its impact was was being shared with certainly the criminal lawyers at the time who would advise on what the impact of that for prosecutions would be.
Did you get any sense, working as you did within the Post Office at a relatively senior level here, of the Post Office reacting as though Second Sight's report was revelatory of matters that it did not know about?
Yes, I did have that impression.
At this time, mid-2013, did you know that there is evidence that the Post Office first knew about the Calendar Square Falkirk bug way back in 2006?
I think if it's Falkirk Calendar Square, I think that seemed to have been a known issue in the company.
We've got evidence that Fujitsu had told the Post Office about the receipts and payments mismatch bug in 2010. And we've got evidence that the Post Office had known about the existence of the suspense account bug in 2012. In fact, knowing about it before Fujitsu did. Did that information come to the surface at the time of the publication of the Second Sight report?
The only thing I can remember coming to the surface was I think the 2012 one when we first knew it. I don't recall, I'm sorry.
Did you gain any sense at this time, mid-2013, that the Post Office was pretending that the Second Sight report was revelatory of matters that it didn't know about, when in fact that simply wasn't the case?
Well, I don't know if I can speak for the whole company, but there was, I didn't get the sense of anybody pretending anything.
Can we
I didn't see any artifice around me, if that helps.
Can we turn to actions arising from the Second Sight interim report? Can we turn up, please, poll 406799? I think that's B79.
Thank you. Yes.
And if you go to the last page, please.
Mm-hmm.
You'll see that this is Mr. Clark's further advice of the 2nd of August 2013. Mm-hmm. And if we go to page 1, please. Mm-hmm. And paragraph 2. In paragraph 1, he says, on the 3rd of July, I attended the Post Office in conference at head office. So this is an advice written a month later where he's summarising or reflecting back what had happened at a conference on the 3rd of July. And in paragraph 2, he says, one of the topics considered by the conference was that of disclosure. I advised there ought to be a single central hub, the function of which was to act as the primary repository for all Horizon-related issues. It would collate from all sources into one location all Horizon-related defects, bugs, complaints, queries, and Fujitsu remedies, thereby providing a future expert witness and those charged with disclosure duties with recourse to a single information point where all Horizon issues could be identified and considered. The rationale behind the advice derived from the need to protect the Post Office from the current situation repeating itself in the future. What did you understand the current situation to be referring to, the risk of which there was a repetition?
I think bugs surfacing which those who ought to be aware of them weren't.
Can we turn, please, with that context in mind, to poll 00191968. B57.
Sorry, this is between bundles. I beg your pardon. Yes.
You'll see it's your email of the 12th of July to Mr. Scott, copied to others, including Ms. Crichton, Mr. Flemington and Mr. Singh, with the subject of regular call re-horizon issues. So I think putting the chronology together, this is after the conference that we've seen summarised by Mr. Clark of the 3rd of July 2013. Yes?
Yes.
And you say, following the call earlier today, I set out a draft email to go to the various heads of regarding a weekly call during which any Horizon-related issues can be raised with the wider business. You ask for comments, and you say someone from Bond Dickinson should participate in the calls we have with Cartwright King, so our criminal lawyers and civil law lawyers are aware of what the other's doing. This will be especially important as further spot reviews come in, which may raise issues relevant to the prosecutions Cartwright King are pursuing. And then the text of the email. We are instigating a regular conference call during which issues with Horizon, user experience and training support can be shared across and known to the various business units which use and rely on the system. This will aim to ensure that all Horizon issues are brought to the attention of user groups who might not be aware of the issues, but whose use of Horizon may be affected by them. To make sure we've all user groups covered, we need to have a representative from each of the following teams, and then you set them out, and you ask for representatives to be put up. Yes?
Yes.
Can we go to paragraph 69 of your witness statement, please, which is on page 35.
Thank you. Yes.
You say in the third line, so I just wait for the screen to catch up, page 35, paragraph 69. You say in the third line, my recollection is that the purpose behind the calls was for issues with Horizon to be raised and recorded so that there would be visibility of them across the business and to avoid operating in silos. I also recall that Post Office's external criminal lawyers were keen to have these calls so as to create a record of Horizon issues which they could consider for disclosure in prosecutions.
Yes.
But would you, that can come down, thank you. Would you accept that the advice that Mr. Clark had given that we've seen about the creation of a central repository reflected no more and no less than a duty that the Post Office had always been subject to retain and record information that was potentially relevant to its prosecutorial function?
I don't think I can make that jump on whether it's part of the prosecutor's duties or had not been. It certainly seemed to be a pragmatic, in fact, necessary development to take matters forward.
So did you see it as a development caused by the circumstances that the Post Office had got itself into, rather than there ought always to have been a process by which information or evidence that was potentially relevant to prosecutions was routinely collated, recorded and made available?
Sorry, I'm struggling to hear. Sorry. Sorry, there are two parts to that. Again, I had the first, but I lost the second. I'm sorry.
Were you seeing this as a development that arose because of the circumstances that the Post Office found itself in?
Yes.
Rather than something that always ought to have been in existence, namely a process by which information and evidence potentially relevant to prosecutions was routinely collated, recorded, and made available to prosecutors.
Yeah, I can't comment on the second part of it. I don't know whether it ought to have been there or not, but it certainly seemed to be something that needed to be put in place now.
Did it seem to you, even as somebody who was not expert in criminal law, surprising that it was only in 2013 that steps were taken to ensure that material was not held in silos?
Yes.
In relation to this proposed hub or forum, were technical specialists from the Post Office and Fujitsu invited to attend and contribute to them?
I certainly think from the Post Office side there was. I don't recall about Fujitsu.
We've seen the cast list, or the departmental cast list that was previously set out. I don't think there's anyone from Fujitsu on that, is there?
No, I don't think. No, I don't think so. No.
And why was that?
I don't know. I may have put that together quickly, and I had a placeholder. I don't know why it's not there. I don't think it was. Sitting here today, I don't think it was a deliberate omission. Put it that way.
You don't think it was?
I don't think it was a deliberate omission.
Well, if the intention or the purpose of the hub was to avoid operating in silos, why weren't Fujitsu invited to attend?
I'd say when I put that together, I was still trying to get my head around how things worked, so I didn't know who the right people were, which is why I had a placeholder in the draft for other. I didn't know whether we had the internal capacity to deal with it ourselves. I think I've subsequently come to know we didn't have that internal capacity. When I wrote that email, I wouldn't have known either way, I don't think.
Going back then to Mr. Clark's first advice, we skip forward to his second to see something that he had written about an event that had occurred in July. In paragraph 80 of your witness statement,
80,
80, yeah,
thank you.
Which is on page 40, you say, the inquiry has invited me to comment on two pieces of advice. I've not taken you to the 19th of July one yet. And then about 5 lines in, you say, I do recall that the 15th of July 2013 advice raised Cartwright King's serious concerns about about evidence which Gareth Jenkins had provided in prosecutions. I believe that those concerns would have been taken forward as appropriate by the Post Office's criminal lawyers, and recall there being a general consensus following this advice that Gareth Jenkins could no longer be used as a witness in criminal proceedings. Were you personally concerned by the advice given in relation to Mr. Jenkins and its potential impact on the safety of historic prosecutions?
Again, there were sort of two parts to that question. Was I concerned? I saw there was concern from the criminal lawyers advising Post Office, so I assumed that was well-founded. I should say it was a positive thing. Quite how it would impact past prosecutions isn't something I could comment on.
Did you form a view that some past convictions that had been founded upon Mr. Jenkins' evidence were unsafe, or at least were potentially unsafe?
I've never been able to form a view on the safety of convictions, I'm sorry.
So you didn't?
I didn't know either way. It's what I could see is that the right people seem to have raised it and would know what to do with it. And they seem exercised by it. That is my recollection. But quite what the impact of it would be, I had no frame of reference to measure it or judge it by.
Can we please go back to Mr. Clark's advice, poll 304, 4 zeros. can we turn up page 11? And look under discussion.
Which tab is this one at? Sorry? Is it 76?
B65.
I beg your pardon. So it's between. Thank you.
But it's on the screen.
Yeah, thank you.
If you look at paragraphs 33 to 35,
Yes.
did you form a view, never mind the implications for historic convictions, but did you form a view that the Post Office could no longer reasonably maintain that the Horizon system was robust in the light of, in particular, the opinion at paragraph 35?
Okay, so I'm sorry, I've read that. Could I have the question again, please?
Did you form a view that the Post Office could not reasonably maintain that the Horizon system was robust or had been robust in the light of Mr. Clark's opinion, in particular that at paragraph 35?
No, I didn't.
Did you think that it was still open to the Post Office to say that, notwithstanding the advice it had received, it could say that Horizon was a robust system and the data that it produced had integrity?
I think it's to me, I don't think so, and I don't think so because it's conflating quite a lot, some isolated examples, admittedly in an extremely serious context. I totally acknowledge that. But I think in terms of the reliability and robustness of the system as a whole, you look at the operation of the system as a whole, which was what Post Office was doing, was being used every day. And
there's so many thousand transactions, there's so many million customers, a billion a year. That line.
Essentially, yes. It's not a line. It was what was happening every day.
It was the line, though, wasn't it? That was the line to take, wasn't it?
I'm sorry, that has a pejorative connotation.
Absolutely.
What you're saying, and I don't believe it was, but it is a line that was used. Yes.
Why were the concerns about Mr. Jenkins not taken to the police to investigate?
I don't know.
Was there any discussion of that?
I don't recall that.
Was there any discussion of which you were a party or of which you were aware that the police should be called in to investigate here?
I don't recall that.
Was there any investigation conducted by the Post Office of which you're aware into Mr. Jenkins and the matters that had been raised in Mr. Clark's advice?
I don't recall, no.
Were any instructions given as to how the information contained in Mr. Clark's advice was to be handled and disseminated?
I don't recall any discussions of that, no.
But was a decision made as to whether or not the information contained in the advice should be disclosed to past defendants, possible appellants, civil claimants against the Post Office?
At that time, this was arising at a time where Post Office's disclosure duties in prosecutions was being considered. I don't know to the extent to which the specific Jenkins witness evidence of this particular advice, I don't know to what extent that folded into it. So I think the answer is, I'm sorry, if you give me the question again, I think I can answer it.
I'll put it another way. Do you know why the information in Mr. Clark's advice concerning Mr. Jenkins was not disclosed until the criminal appeals in November 2020?
I don't know why it was. I don't know why it wasn't disclosed.
That can come down from the screen, thank you. Given that Mr. Clark's advice about Mr. Jenkins concerned the probity and integrity of one of the architects of the scheme, of the system, Mr. Jenkins himself? Was consideration given to whether that had a wider implication on the reliability of the Horizon system itself?
No, I don't recall that, no.
Were the concerns about an employee of Fujitsu, to your knowledge, then discussed with Fujitsu?
No, I don't know.
What did you try to do to ensure that people in Fujitsu who needed to know this information got the information that one of their employees had, according to the post office, been given discreditable or tainted evidence in court?
That's really, can I check the privilege point on that, because we're dealing with...
No, just answer the question.
Okay.
If somebody wants to take a point on privilege,
I'm sorry,
they'll stand up.
Thank you. So could I have the question again, please?
What steps were taken, to your knowledge, to raise any concerns about this employee of Fujitsu with Fujitsu?
I worked with Womble Bond Dickinson to work out an approach that we could, correspondence, a means by which we could raise the issue with Fujitsu, which we started off, I think, looking at drafting a letter that would bring it to their attention.
Mr. Williams, one conclusion that might be drawn from the fact that the post office, or part of it, acted as if the 3 bugs raised by Second Sight was revelatory, that no one investigated what knowledge the post office in fact had of the 3 bugs and when, and no one disclosed the post office's view that the expert that it had placed reliance on was discredited, was that the post office had now entered a cover-up mode. Is that true?
So again, there's quite a lot in these things that don't know. So I think you're asking me could somebody see that? I think somebody probably could see that.
Well, is it factually correct? Was a decision made, let's not find out when we in fact knew about all of these bugs. Let's, at least some of us, pretend this is revelatory.
That wasn't the impression I had.
Let's not disclose to convicted defendants that we have taken this view of an expert who has given evidence, or a witness who's given evidence either in writing or orally in court. Is that we're now entering a phase of seeking to cover up what's happened.
I think to do that requires a positive decision, and I'm not aware of that decision having been made or communicated to me, or I became aware of that in any way. I accept actions weren't taken, but whether that was, I wasn't aware of anything that said that was a deliberate choice.
So you're not aware of any sort of master plan, as it were, that said, let's not investigate when we in fact knew about this. Let's, to the outside world, suggest that Second Sight has uncovered something about which we didn't know. Let's not tell convicted defendants about the view we've taken of Mr. Jenkins' evidence. There was no meeting of that kind or instruction of that kind.
Not that I was aware of in any way.
Did you view...
Well, that I recall, anyway. I mean, I think I would remember something like that, but I don't recall that.
Did you view the issue raised by Mr. Clark's advice as relating solely to the Post Office's past criminal prosecutions?
Yes.
Accordingly, did you not consider the potential impact on past civil actions?
No, I didn't.
Did anyone do that?
I don't believe so.
As a lawyer with significant experience of civil litigation, at the centre of the team that was dealing with Horizon at the time, if anyone had considered the potential impact on civil proceedings, you would have been aware of it, wouldn't you?
I would think. Oh, yes, I would. Sorry, yes.
What did you, in fact, do as a result of the receipt of the 15th of July Simon Clarke advice?
I think I read it.
And put it away?
I suspect, yes, it was being dealt with by what I considered to be what appeared to me, I should say, to be the people who were advising the business on the steps that should be taken. I'm not sure that what I saw in there necessarily impacted other activities in the business. He hadn't, I don't know, I wasn't aware of him giving evidence or any live proceedings at that time where the particular issues raised in here were germane.
Going back to the advice, please. Poll 304, 4 zeros. And page 13, please.
Yes.
Under Mr. Clarke's conclusions, what does this all mean? In short, it means that, I'm going to replace the text where it's the correct name, Mr. Jenkins has not complied with his duties to the court, the prosecution or the defence. And then paragraph 38, the reasons why Mr. Jenkins failed to comply with his duty are beyond the scope of this review. So in 37, Mr. Clarke advised that Mr. Jenkins had not complied with his duties to the court, the prosecution or the defence, and 38 said the reasons why he failed to comply are beyond the scope of his, Mr. Clarke's review, correct?
Yes.
Do you agree, therefore, that it left that question very much widely open?
I wouldn't have said very much widely open. I think if there was actions to be taken, I would have expected them to have been advised on next steps. What else is to be done?
Well, you would agree, I think, with this, that the reasons why Mr. Jenkins failed to comply with the duty was an important issue.
That certainly seemed to be what the criminal lawyers were saying.
It was an important issue that demanded answers.
I don't know what the issue, what the follow-on steps from it were, because that was for those with the expertise to advise on.
Was it not considered imperative to ascertain the circumstances in which Mr. Jenkins had given written and oral evidence in some post office prosecutions and, according to Mr. Clarke, had breached his duties to the court?
I really can't comment on matters of the criminal justice system. I just had no familiarity with it and what was required or not required.
Did you ask questions of Mr. Singh, or indeed any other of the lawyers in the department, or engaged in discussions with them as to whether Mr. Jenkins had been properly instructed as to his or an expert's duties of disclosure? I think I recall raising orally with Cartwright King. And what was the answer you got back?
Oh, I'm sorry?
What was the answer you got back?
I don't recall one.
Did you ever see any instructions which the post office had provided to Mr. Jenkins that might properly set out his duties to the court?
I haven't seen that, but also I didn't look for it.
When you read this advice, did it give rise to any concern in your mind that what you read might be indicative of any broader prosecutorial failings by the Post Office?
No, because I didn't know enough about the prosecutorial process to know where it may lead. It certainly seemed to be addressed seriously by those who understood the context in which it was relevant. So I don't know where else it would have gone beyond that, I'm afraid.
Were you aware of any discussion within Post Office legal at this time as to whether the appropriate course might be actually to speak to Mr. Jenkins to understand events from his perspective?
I don't recall that, no.
So thank you. That's a convenient moment. It's just up to 3:10 now. Might we break until 3:25?
Yes, of course.
Thank you, sir. Good afternoon. Can you see and hear us?
Yes, I can. Thank you.
Thank you very much. In the next set of questions, Mr. Williams, please don't worry about issues of privilege. They have been resolved between the inquiry and the Post Office.
My apologies for that.
No need to apologise. Can we look, please, at poll 00193383? Can you see at the foot of the page, there's an email from you to Leslie Sewell, Susan Crichton, Simon Baker and Hugh Flemington of the 11th of August 2013. And you say, Leslie, please find attached 2 drafts of a letter to put us on the record with Fujitsu about the issues raised in Second Sight's interim report and the impact of them on court proceedings we bring. The drafts differ in tone. The, quote, shot across the bows aims to put pressure on Fujitsu to work with us to improve Horizon and user confidence in it. The letter of claim goes further, tying the issues to our contract with Fujitsu and escalating them through its dispute resolution procedure. In either case, we need to set out what we want Fujitsu to do. That should set the tone for the letter. The more aggressive we are, the more defensive and therefore less supportive Fujitsu are likely to be. Can you tell me which approach to take? Can we look, please, at poll 00140620? Can you see...
Could I get a reference, bundle reference?
Yeah, E77.
B?
E77.
Yes, thank you. I have it, thank you.
This is headed up letter of claim, and it appears to be one of the 2 attachments to your email, albeit I'm not clear whether it's the shot across the bows letter or the formal letter of claim letter. I don't think that matters for present purposes because it's the content that I wanted to discuss with you. Can you see it's a draft letter to Fujitsu and says it's a letter of claim pursuant to the practice direction? In the background, it says Post Office has commissioned an independent inquiry into Horizon, which is being conducted by Second Sight. The report was published on the 8th of July. Although the report found no evidence of system-wide problems with Horizon, a number of criticisms were levied against the system, and further investigations are ongoing. In particular, Second Sight highlighted the following areas of concern, and can you see that 6 are then set out? Yes?
Yes.
Along with a note saying this list is taken from Second Sight's report. The Post Office needs to carefully consider whether responsibility for these criticisms falls on Fujitsu or the Post Office. And then over the page, it's noted the above criticisms are a product of only an interim review. We know there are a number of other potential allegations. Further details of these issues will be presented once received from Second Sight. One major area of concern is the scope and quality of Fujitsu's support to Post Office and court proceedings. Where appropriate, Post Office commences criminal prosecutions against sub-postmasters believed to have acted criminally, also brings civil proceedings. Data from Horizon is integral to the success of these court actions. It's imperative that this data is and is seen to be reliable. Perceptions of weakness in the system or any suggestion that Post Office or Fujitsu is attempting to hide weaknesses seriously undermines our credibility and significantly increases the complexity and the cost of court proceedings. And this is the paragraph I wanted to ask you about. The Post Office was therefore disappointed to discover that witness evidence prepared by Fujitsu may not have been fully disclosing historic, albeit known and resolved defects. This has led Post Office having to review all its historic criminal prosecutions for the last 3 years since the rollout of Horizon Online to ensure that it has not breached its duties of disclosure under the criminal court rules. Was your reference to the witness evidence prepared by Fujitsu a reference to the witness evidence of Mr. Jenkins?
I think it must have been, yes.
Was it the case that the Post Office discovered by the Second Sight report that he, Mr. Jenkins, may not have been fully disclosing historic defects?
So the question again, you said from the Second Sight report.
Was it the case that the Post Office only discovered from the Second Sight report that witness evidence prepared by Mr. Jenkins may not have fully disclosed defects in Horizon?
That seemed to me to be the case.
What investigation had taken place by the time of you drafting this letter in August 2013 to be able to say that it was only the Second Sight report that had caused the Post Office to discover those facts?
I'm not sure. I'm sorry. I think the question is what investigations. I don't think any investigations were undertaken. So I think it must have been that was the perception, the feeling. Although I have to say this is also a draft, so we may have invited comment on it before progressing.
And it's about that perception and feeling that I want to ask you. Remember before the break, I asked you questions about pretending that it was only upon the publication of the Second Sight report that the Post Office discovered facts that Mr. Jenkins may not have been fully disclosing historic defects in Horizon. This is an example of that, isn't it?
Of the perception that it was, yes, it would be, yes.
That it was a new discovery.
Yes.
A new fact.
Yes.
And I'll ask you again, what had been undertaken within the Post Office to discover whether that was true or not, that this was the discovery of a new fact, as opposed to something that the Post Office had in fact known about all along, the existence of the 3 bugs?
We didn't do anything, I don't think.
Can we turn, that can come down, thank you. Can we turn please to poll 0015 5555. This is a manuscript note dated the 2nd of September 2013. The authorship is not shown on the document, but do you recognise the writing?
It's mine.
You wrote this?
I think so. It looks like mine, yes.
And it appears to have been written by somebody, i.e. you, who had read Simon Clarke's advice of the 15th of July 2013. It refers to conversations with Martin Smith of Cartwright King and Brian Altman, KC. Can you see, if we pan out a little bit, please?
So, can I have the reference?
Yes.
Please. Just,
Thank you. E96.
Thank you.
Are you at E96?
Yes, I'm sorry, I am. I've just been reading it. I'm sorry.
Thank you. Could you translate what the first part says, please?
It appears to be draft BPs.
Yes.
So the first piece is horizon hyphen FJ positioning. Then it appears to be draft BPs.
So if we can expand that first bit, please. Draft, is that bullet points?
It might be. That seems sensible, but I don't know. So.
Okay. And then carry on translating, please.
Reports didn't contain all they should have. Reluctance to deal with known issues as a which would be consequence. Do you want to verbatim
keep
for
going.
so NECS, which would be necessary to review cases to determine whether or not a partic deft, which I think
Particular defendant.
correct, was prejudiced by absence of info.
And then scroll down, please. You look at the next bit, copies of advice. Can we blow that up, please? Just under the part we were looking at.
I can probably do that from here. Copies of advice,
Yeah.
arrow, share under common interest privilege.
Can you help us? To whom was the advice to be shared under a common interest privilege?
I anticipate that would have been with Fujitsu.
Did that happen?
I don't believe so.
Do you know why it didn't happen?
No.
And then carrying on, please, the 6 statements.
6 statements as examples, hyphen, might, underlined, be, quote, tech correct, to be technically correct, I imagine, but no in substance.
So 6 statements as examples might be technically correct, but not in substance.
Yeah, I think we might be missing a T. I think
Yes,
right.
and you've written that against paragraph 34 of the advice.
That does look right. Yeah.
And then underneath, please.
It goes to fairness / I think that might be obligations to do justice.
Thank you. And then next, telephone to MS.
Yeah, that's right. Ent report revealed existence of bugs.
Yes, and then underneath, does that say clashed with Gareth?
I think it does, yeah.
And then to the right-hand side of the squiggle.
And I've got without this, that'd be would have, so would have, continued with premise, all is okay, brackets, as per GJ.
What does that mean? What are you saying in this note here? Are you referring firstly to a telephone conversation with Martin Smith
Yes.
of Cartwright King?
Yeah, I'm going without this. I think that may be, I fear I might be speculating a little bit because it's been a long time, but would have continued, presumably with prosecution activities, with premise that all is okay.
As per Gareth Jenkins.
As per Gareth Jenkins.
So translating that, do you think that possibly means without the second site report, we would have continued to prosecute on the premise that all is okay, as Gareth Jenkins said it was?
I think that's right, yes.
Thank you. And then the box over to second site report.
But SS report equals, he tells of bugs not mentioned in his statements.
Yes, and then on the right-hand side, his statements say
we have lists to check, but doesn't say what types, what happens as a outcome.
Okay, and then scrolling down, please. You asked the question, what else?
Yep.
Is that a note to yourself?
I don't know. It's certainly it's my note, so I don't quite know what that's referring to.
Do you think it means?
There might be other bugs. I think that's as I'm
Yes.
trying
If
to
it's
read
been
it.
discovered that Mr. Jenkins has said to second site, i.e. he tells of bugs, Mr. Jenkins said things to second site about bugs that were not mentioned in his statement. What else is there to discover about what Mr. Jenkins has not said?
I mean that might be correct. I don't recall what I was putting that to, but
Okay, we do have an issue. I
with
think it's
how
the next line.
yeah, we do have an issue with how we share the info.
What was the and sharing with whom?
I don't know what that's relating to. I don't
You remember I asked you earlier about whether the Post Office had considered whether it needed to disclose the information in Mr. Clark's advice about a view that essentially Mr. Jenkins was a tainted witness, he had breached his duties to the court, needed to be shared with convicted defendants. Do you think that was part of your discussion with Mr. Smith?
That's plausible, but I don't know.
Why were you discussing these things with Mr. Smith if your expertise was not in criminal law?
I don't know. I may have been just the one who was asked to see what we did. But I'm certainly speaking to Martin Smith, who does have the expertise. Oh, I'm sorry. I do know why. I beg your pardon. Sorry, it's come back to me. One of the outcomes of the second site report was dealing with Fujitsu, and I was asked to sort of help with that. That was sort of on my agenda.
Underneath Martin Smith, and I think that says inference,
Yes.
can you tell us what bullet point 1 is?
I think that's system designed to look for bugs, but doesn't mention any. By implication, there are none, because none are mentioned.
And then to the right-hand side, dealing with this page as we go down, you've written, so we know of some of these, and then what were we doing to instruct Gareth Jenkins? You remember I asked you before the break
It looks like
whether the question of what the Post Office had done to discover the instructions that it had given to Gareth Jenkins were, and you said you don't think consideration was given to that, or you couldn't recall any consideration.
No.
It appears that such consideration was given by you.
Oh yeah, well I thought I did say that I'd raised it with Martin Smith. I thought I did say that in my answer. Didn't I? I thought I did. I beg your pardon.
What was the product of your discussion with Martin Smith then as to the issue of what the Post Office had done properly to instruct Gareth Jenkins?
I don't know from this. I don't think any actions were taken.
I mean, was there any introspection at all here by the Post Office? To what extent do we, as Post Office, bear a responsibility for what has been revealed by Mr. Clark's 15th of July advice?
Oh yes, I would think so. And on that, we'd have been asking those who advise on the appropriate, who raised the issue, on the appropriate steps to take next.
Was anything specifically done to answer the question that you raised there? What were we doing to instruct Gareth Jenkins?
So the question again? I'm
Was
sorry.
anything done?
I'm still familiarising myself with the document, I'm afraid, sorry.
But what was done to take that issue forwards, to your knowledge? Discovering what the Post Office had done properly to instruct Gareth Jenkins.
I don't know that anything was done.
Was there any sense that you're aware of, let's best not answer that question, because we might not like the answer?
Not that I recall, but
Carrying down on the left-hand side, please. M. Smith, first point, don't think
has ever been advised of his duties. There you go.
Who's the he?
Oh, there must be Mr. Jenkins, I think. Must be Mr. Jenkins. Sorry, my voice dropped.
So your criminal law expert was telling you that he didn't think that Mr. Jenkins had ever been advised of his duties. What was done as a result of that?
Again, I don't know. I'd been looking to Martin Smith for the reaction to that.
But you're the company lawyer, aren't you? You're the Post Office lawyer, and your external lawyer is telling you, we don't think this expert who Simon Clark has written a very powerful advice about, with very concerning and difficult conclusions in, was ever advised by the Post Office or anyone of his duties. What did you do with that information?
What I do recall, but I cannot say it was in context of this. I remember in the various discussions I may have had with Martin over the time that if there was action we needed to take.
So what action was taken?
Well, none. But it was saying if you tell us we need to do something, I genuinely think Post Office would have been doing it.
Well, did you say back? Well, that's an important point. We, after all, are the prosecutors here. It's Post Office Limited on the charge sheet. We owe duties to the court. There needs to be some investigation here of what we, the Post Office, have done wrong, if anything. Can you look into that, please, Martin, rather than lumping it all on Mr. Jenkins?
Well, I don't know. We're doing that. This is a discussion on how to take something forward with Fujitsu, with the criminal lawyer, and I'd have expected through this, given I'm not a criminal lawyer, for the advice on what's appropriate or not to be taken to be coming in that, well, from the expert.
Underneath, does that say started with MISRA 2010?
Yes.
And then if you can read the final 3 bullet points on that page.
Has turned up since, but not given.
So does that mean, do you think in context, Mr. Jenkins had turned up to court since 2010, since MISRA, but hadn't given evidence, as in fact was the case?
That's my understanding. Yes, I think that's right.
His duty is to the court.
Yes.
And then what does the last bullet point say?
It seems to say, seem to rely on this. CK haven't done anything since.
Do you know what that means?
No. I'm sorry.
And then the final part on the right-hand side of the page, underneath the part that was double underlined, signed statements.
After telling SS of the bugs.
Does that mean that Mr. Jenkins, or you were being told that Mr. Jenkins had continued to sign witness statements that didn't make mention of bugs, even after telling second sight of the bugs?
I think so, yes.
We'll come to that later in this phase. Fujitsu will say, can you translate the rest, please?
It's up to Defence Counsel to raise the issue.
Do you know what that is? Is that Mr. Smith speaking there?
I don't know. I don't know who put that. It may have been me, it may have been him.
Can you help us with the context of that? I.e. Fujitsu will say it's up to Defence Counsel to raise the issue.
My guess is in terms of bringing us to the attention of Fujitsu, they'll say, well, you were conducting the prosecutions, you should have told him it's your fault.
And then the last part on that page, in the bottom right.
I think it's wholly affected, hyphen, I think they might say it's cute. And then it's RFJ legal reviewing this.
Are Fujitsu legal reviewing this? Yes.
And then it's a quote, and correctly account for it misleading.
Can you help us with what that note means?
No, I'm sorry. I mean, I don't know what this is. I'm
What, one of their employees might have breached their duties to the court, presumably.
I don't know. I'm sorry. I don't know what that is.
Okay, over the page, please, to page 3. Is this a continuation of the same note?
Quite possibly, yes.
Can you help us with what the first part means?
It says Fujitsu, this is how we did it, and confirm.
Yes.
Plus, we don't do bug-free. It's up to you what you do with the system. Plus, per CK, Defence Counsel should raise this.
Is this Mr. Smith telling you what he thinks Fujitsu might say, you recording what you think Fujitsu might say, or something else?
I don't know now, I'm sorry.
And then I think the rest is either irrelevant or ascertainable and irrelevant. Do you think by this time the Post Office had realised that it had failed to instruct Mr. Jenkins properly as an expert witness?
Oh, yeah, yes, I'm a Post Office employee, so yes.
If the Post Office had failed to instruct Mr. Jenkins properly as an expert witness, in accordance with the Post Office's own legal duties, would you agree that that was a serious issue?
If we'd been advised it was, yes.
Would you not regard it as serious of itself without having to be told?
In this context, I mean, we knew it was serious because it had been raised, but what to do with it? Again, I'm sorry, could I have the question again?
If it was the case that, as this note may indicate, it can come down incidentally, that the Post Office, through you, realised that, or had been advised, that the Post Office had failed to instruct Mr. Jenkins properly as an expert witness in breach of its own legal duties, then that was serious.
Well, I didn't know what Post Office's duties were, which is as a prosecutor, which is why I was speaking to the criminal lawyers.
We've seen a note which says we don't think he has ever been advised of his duties. Did you think that was serious?
Well, I don't know. I'm not sure in the civil context when we. Oh no, we do with experts. You're right. So yes, I do think it's serious.
Why were you having this conversation with Mr. Smith?
Well, because we wanted to raise it with. We thought it needed to be raised with Fujitsu. That was the. What are we going to raise with Fujitsu?
And the type of issues that we see discussed here,
Yeah.
namely a record of a witness continuing to sign witness statements that fail to mention bugs, even though he's told Second Sight about them, a record of the breach by the witness of his duties to the court, a realisation that he, it is said, has not been advised of his duties to the court. Were they, to your knowledge, ever raised with the Post Office Board?
I don't know with the board. I think they were put in. There are other drafts of letters to Fujitsu, I think.
Yes, I'm talking.
Which
we can see what was said in that draft letter.
There were others, I think.
I'm asking where else that information was directed. Was it sent up to the board, to your knowledge?
No, not to my knowledge, no.
Was Second Sight told about it?
No, not to my knowledge.
Was the mediation scheme working group told about it, to your knowledge?
I don't know whether they were or weren't.
Was Mr. Altman at KC told about it?
Of the issue with Gareth Jenkins?
No, I'm taking it beyond the issue with Gareth Jenkins. I'm talking about a realisation that the Post Office itself may have failed to instruct Mr. Jenkins properly as to his duties.
Quite possibly not. I put it this way, I don't recall him being told that, no.
Was it, to your knowledge, raised with the CCRC?
No, not unless it sort of came out from the advice notes we'd had, no.
To your knowledge, was the first time that the Post Office acknowledged to any external body that Mr. Jenkins had not been properly instructed as an expert until this inquiry?
Quite possibly, yes. Oh, it may. I don't know. It may have come out in the Court of Appeal proceedings.
I don't think there was any, from memory, direct acknowledgement in the Court of Appeal proceedings by the Post Office that was so.
I'm sorry, I'm speculating there. I beg your pardon.
Can we turn, please, to poll 00125758? I'll give you the tab number in a moment. 00125758. B176, Mr. Williams.
176.
Yeah, B176. Have you got that?
Oh, I'm sorry, I beg your pardon. Yes, I have. Sorry.
You'll see this is a speaking note for a meeting with the CCRC on the 8th of May 2015.
Yes.
You can see who the attendees were intended to be. From Post Office side, you and the General Counsel, Ms. MacLeod. Did you write this speaking note?
I think I may well have done.
Yes. And if we just scroll through it, please. You propose to set out the background to the complaint review and mediation scheme. Post Office is a retailer. It's the UK's largest branch network, 11,500 branches, 8,000 agents. Postmasters handle Post Office money, £70 billion in cash. There's a duty to account under contract and common law, under agency, for daily cash declarations, weekly balances, and monthly trading rollover periods. Post Office monitors branch accounts. There's an audit if questions about declared levels of cash holding. If audit reveals a shortfall, then the Post Office seeks to recover under a contractual right that shortfall, and you quote in clause 12 of the contract, suspend, termination, potential prosecution if conduct is suspected, prosecutions under the POA, about 50 a year. Over the page, please. Post Office uses the Horizon accounting system in every branch. It's supplied by Fujitsu. First introduced in 1995, online in 2010. 60,000 users or more, processing 6 million transactions a day, 2 billion transactions a year. 500,000 users since launch. The key principles of it, 2.3, some postmasters started attributing branch losses to Horizon. Early 2012, James Arbuthnot asks the Post Office to look into it. From your knowledge and understanding, was that the first time that the attribution of branch losses was raised in early 2012?
I think I don't know when PMs started attributing branch losses.
And you knew, I think, about the Castleton case.
Yes.
So he had been doing it in making that suggestion in the early 2000s.
Correct. Yes.
And you knew about the Seema Misra case, and she had been making that suggestion in 2009 and 2010.
Correct.
And did you know about the Computer Weekly article that summarised half a dozen or so sub-postmasters who said exactly the same thing?
I'm aware of that article now. I don't quite know when, but it was likely by this time that...
By mid-2015, you would have been aware of the Computer Weekly?
Yes, absolutely.
Okay, so is it right that then this is not supposed to be a comprehensive account of when problems with Horizon first arose?
No, I think what I've done here is PMs at some point started attributing losses, but then in early 2012, that's when Lord Arbuthnot
Okay,
forward. So I'm not seeking to say it started in 2012. I think it's a
Okay.
bullet point.
In 2012, Post Office instructs Second Sight to look at some of the cases. The first report was in July 13, and you cite the no evidence of system-wide systemic problems with Horizon software, but issues with the way we dealt with individual postmasters. Post Office was very concerned about the impact on criminal cases. It considered the July 13 report against the prosecutor's duty of continuing disclosure, set up a SIFT review process. Suitability was checked by Brian Altman, made disclosures as a consequence, revisited its approach to agent engagement. And then 2.5, scheme to resolve individual complaints. You'll read what's summarised there. And then over the page. 2.6, focus of complaints continue to be processes and practices. The Second Sight investigations, you told the CRC, have shown that the majority of branch losses were caused by errors made at the counter. Second Sight expressly accepts it's not an expert in criminal law and procedure, but still, in Part 2, state the Post Office might not have investigated claims properly, have the evidential foundation to bring a criminal charge. These statements have entered the public domain and may encourage people to take action. Other avenues being pursued. And then categories of responsive documents under Section 17 notices, if you just scroll to the end. You enter into a practical discussion about provision of material. Yes? Yeah. Why is there no mention there of what the Post Office have found out about Mr. Jenkins?
I think by this stage we had disclosed, we may have disclosed the Brian Altman advice reviewing the past. What I understood the impact of the Jenkins the Jenkins issue was that it triggered Post Office's duty to make further disclosure, or to consider further disclosure in case
of the Second Sight report.
Of the Second Sight of the materials that we'd been advised to disclose, which I think was in some cases the Second Sight report, in some cases, in most cases I thought it was both, the Helen Rose report. That process had been reviewed by Brian Altman, and the advice on that had, I think, although I'd like to check the dates, been shared with the CCRC by the 8th of May 2015. If it hadn't been, it was around the time of this. It was
And
disclosed.
the Simon Clark advice
Of
the 15th of July 2013?
I don't think the Cartwright King advices were shared.
And why was that?
We tended to respond to requests for information from the CCRC, and it was the Cartwright King advice was referred to in Brian's advice, and we invited the CCRC to tell us which documents they would like from it, and some of those were, I believe, provided, but not those. I think that's what it is.
How would
Certainly,
the CCRC know about the Clark advice?
it would have been referenced, I think. I hope. They would only know, I think, if it's properly referred to in Brian's advice.
Mr. Ortman's advice?
Would you like me to check to see whether that?
No, it's okay. We can
That was
do
done. I don't want to mislead. That's my recollection, but I'd like to check it.
Why wasn't it something volunteered?
I don't know. It's some things were volunteered, I think, but it wasn't a routine.
Yeah, I'm asking about this one.
No particular reason. The material they asked for was provided. It indicated what else there might be. And so, I don't know at this time, but certainly the process we had going forward with them was not to show them what we thought they might be interested in, but for them
Rely on
to
them to
conduct
ask.
for them to conduct their investigation and follow the lines of inquiry that they would want to. That was the repeated advice I recall us receiving, is the CCRC would conduct their own investigations and should be left to it.
Can we look, please, at poll 0010 3238? I'll just wait for Mr. Stevens to turn that up. Poll 0010 3238. B182, please.
B102, thank you. Yep.
And can we turn to page 2, please? And scroll down. We can see an email here of the 1st of August 2016, and if we scroll on, please. If we keep going. We can see that it's sent by Amanda Pearce, the group leader of the CCRC. And if we go back to the beginning of the email, please. She says, hi, Rodric. And then under documents, I'm afraid I've also got some further requests for information and documents. Under documents, we met with Ron Warmington of Second Sight. He mentioned a couple of documents we think it'd be helpful to see. The thematic spreadsheet, which Second Sight created, identifying the alleged faults and problems. A June 14 report, which Mr. Warmington prepared on Post Office Investigations Department and process. I attach a Section 17 notice to cover the request. We're trying to locate the transaction logs for the Misra case. We haven't been able to find them in the data room. We have found a 255-page event log and a 29-page log of transactions, but no sign of the full transaction logs. If the logs weren't printed out at trial, are you still able to access them? I haven't sent a Section 17 notice. And then scroll down. In November 15, Post Office reported an issue whereby payments had been duplicated on Horizon. It was reported that this was caused by the user forcing log-off. We've also seen this referred to as the Dow-Mellington error. Would it be possible for the Post Office to provide us with an explanation of this issue? 2, we've seen a number of references to the receipts and payments mismatch problem, which we think has also been referred to as calendar square, Falkirk problem. Are we right in thinking they're the same thing? Could the issue affect transfers between stock units within a branch? 3, we've seen references to some sort of fault log produced by Horizon. I understand that this has been variously referred to as the peak incident report, Pinnacle, and the known error log. Do these refer to the same thing? Is it one document or is it a series of documents? I'm trying to get a better sense of what they are. Agree all very relevant, direct and penetrating questions.
Yes.
Can we scroll up, please, to page 2? And keep going. And keep going, please. To the top of page 2. There, that's it, thank you. You send this on. We just look at the bottom of page 1. That's from you. You send that email on to Andrew Parsons and others and say, can we discuss it? I'd like to start thinking about whether and how we can start forcing the issue with the CCRC. They've been looking at these for a long time and seem to be jumping down every rabbit hole they're directed to. Why did you think the CCRC was jumping down rabbit holes?
For 2 reasons, I think. Now, the Computer Weekly issue was I think it referred to an outreach bug, which I think when we discussed it in turn, I don't know where it came from, seemed to have been a recent event. I'm not sure whether that actually is the case or not, but that's what I recall being at the time. But I think more pressingly, they'd asked for quite a bit of disclosure on an employment tribunal claim that was, as far as I was seeing, it was an employment tribunal matter, not a. It was unrelated to any prosecution material, and it just what I think was going on there was certainly what my impression of what we were seeing was lots of people raising lots of issues that would get looked into and not go anywhere, and just extend the period of review without reaching conclusions.
You just agreed with me a couple of minutes ago that the questions that the CCRC were raising with you were relevant, direct and penetrating issues. Why did you think they were going down rabbit holes?
What I think what I've just said, for example, the Computer Weekly. I think that I'll be frank, I think that's just me writing a short email. I think what I was trying to actually do is what Post Office's approach to the CCRC had been was to, as I said before, leave them, and that was the consistent advice, leave them to their investigations. They knew what they were doing and how they would go about it. I think around this time, because the group litigation had started, I think it started, in April 2016, there was some discussion around, well, how long does this take? That's a question I was frequently asked. And I thought it important to at least think about testing what had been our position and to see whether it was still viable and valid. You know, is how we've been dealing with this appropriate? Should we be thinking about doing something else? And that's what I was trying to do there is, is this an ever-expanding running down the rabbit hole, as I seem to have intimated there, or should we stick to what we have been doing and what I believe we continue to do, which is to engage with them as they required from us.
It's that siege mentality again, isn't it, Mr. Williams? Challenges to the Post Office are hostile and must be fended off rather than considered on their merits.
I think that's maybe overstating it, but there's probably something in that. I think that's fair.
You say that they're being directed to rabbit holes. Were you paranoid that others were acting in concert with the CCRC?
I said seemed to be. I didn't know whether these were things they got to on their own or at prompting. But I'll be frank, I'm quite sure they would have been doing what they do with us, which is their own investigation impartially.
Did you think they were lacking impartiality?
No, not in any way.
Why did you want to force the issue with the CCRC?
I wanted to start thinking about whether we can. As I say, to me, this is testing. Is our approach still the right one? And it turns out, I believe, as our subsequent actions, it was the right one, to continue to leave them to do the job as best they knew.
Well, is there really an option there? On the one hand, we should leave the statutory body that investigates possible unsafe convictions and miscarriages of justice to get on with its work, or we stand in their way.
I don't think so, but I was often asked, I seem to recall being asked, when are they getting back, what can we do? And it helped me to be able to say, look, this is the approach we've been taking, we're keeping it under review, we test it, and it is still the right thing to do. Even if it seems, as you just laid out, frankly, obvious. I think it's important to keep things under review.
Can we look at a different aspect of this, please, and turn to paragraph 76 of your witness statement? That can come down there. Which is on page 38.
Oh, sorry, yes.
I think that must be a rogue reference. I'll move on. Poll treble 06, 6789, which is tab B64. This is an email chain between you and Mr. Smith regarding disclosure of the Helen Rose report. You remember what the Helen Rose report was?
Yes.
Can you, for those less familiar, summarise your present understanding of what the Helen Rose report was?
I think Helen Rose report, it's just unfortunate we tried for a while to have it referred to as the Lepton report, as it concerned a branch rather than an individual, was an issue raised by a member, I think, of Post Office's security team in connection with an issue raised by Second Sight through a spot review, ultimately through a spot review on, I actually can't remember what the technical piece is, but it's how system reversals, I think, are visible from information derived from Horizon.
Thank you.
Question about whether the reversal was generated by the system or by a user.
Can we turn, please, to page 4 of this chain? At the foot of the page, in the context of the case against Mr. Ishak in July 2013, Martin Smith sending a copy of a letter to Mr. Flemington and copied to you to be sent to Mr. Ishak's solicitors. And then up the page, please. Keep going. We can see your reply on the 10th of July 2013. Thanks, Martin. First point, we presume that Helen Rose's report is being disclosed because the Post Office's evidence in the prosecution included an ARQ report. Is that right? Second report, Helen Rose's report is marked confidential and legally privileged. I understand she did this because she prepared the report to give to Post Office Legal for advice, for legal advice on the implications of her investigation. Please call on her number to confirm. Please therefore consider what information from the report needs to be disclosed to Mr. Ishak's solicitors and in what format, i.e. whether parts of the report should be removed or redacted, e.g. the recommendation section or the non-privileged material, e.g. the background transaction data repackaged for disclosure to the defence. If you advise that Helen's report does not attract any privilege, please ensure the reference to privilege is removed from the header. I don't want someone else to say the report is privileged, but we waive thereby giving rise to possible difficult issues of collateral waiver. So you were asking Mr. Smith why the report was being disclosed first, yes?
Yes.
And you were asking for advice on its privileged status. On what basis did you consider the report to be privileged?
Well, I wasn't sure whether it was privileged or not, which is why I was asking the question. But I had understood when this came up that the report, and the physical report, had been prepared for the purposes of obtaining legal advice. And here's an issue, what do we do?
And so what did you think that occasion of privilege was? To obtain legal advice about what?
Whether it raised issues that needed to be disclosed.
No, why did you think it was possibly the case that the Helen Rose report enjoyed privilege?
Well, it's the same, because I thought it had been prepared to give to the Post Office Legal for advice. We found this issue. What are the legal implications, Post Office Legal? That's what whether that actually was the case or not, I don't know, which is why I was asking Martin Smith what his view on it was. And it was marked privilege, which I know isn't determinative of anything, but somebody thought it was privileged, and I wanted to know, and not having any familiarity with the criminal justice system.
In any event,
I wanted the expert to tell us what to do.
If we move up, please, to page 1. At the foot of the page. Mr. Smith says Rodric, and then there's an explanation of privilege. And second sentence, I guess here you suggest that such privilege attaches by reason of the Post Office's contemplation of adversarial proceedings involving Fujitsu. Is that right? You thought that Helen Rose's report was... No. That's just way off beam.
It was.
In criminal litigation, the emphasis is on ensuring a defendant is not prejudiced by the absence of material which would otherwise assist him or undermine the case against him. Criminal disclosure law trumps civil privilege, but only in circumstances where the material in question meets the test for disclosure. Quite a lot in there. Thus, there are only a limited number of ways in which we can prevent disclosure of material which we would otherwise be required to disclose to defendants. Then over the page. Seek a public immunity, I think that's meant to mean public interest immunity, certificate from the trial judge, as we did in another case. To achieve this, we would need to demonstrate a real public interest in non-disclosure or terminate the prosecution. And then he sets out why Helen Rose's report is disclosable. And if we go to page 3, second paragraph, I'm in no doubt that this document is disclosable. If the matter were to come before a criminal court, the judge would without hesitation order the disclosure in an appropriate case. Then I think you gave your instructions on page 1. Please disclose all information from the report that needs to be disclosed. Do so in a form of a new standalone document. Helen presented the info in the form she did as to provide it to the legal department for its view. Why did you want a new standalone document?
I think it just separated that I think I said it earlier, it just removed any question about what had been prepared for. I had been told, I think, by Cartwright King that you can give disclosure in the form of disclosure notes as opposed to the document itself. And I had thought, look, they know what needs to be disclosed from there, which is the key of it. You disclose what needs to be disclosed. Do it in a way that sort of removes the question around this.
Would that not have had the effect of obscuring the context in which the report had been originally generated?
Not necessarily. It could have been as simple as removing the privilege piece, which I think is what happened. I think I saw a version of it at some point where it effectively went without the markings. But certainly that wasn't.
And then lastly on this topic, before the break, can we look at poll 0010 8163, please?
Yes.
An email from you to Martin Edwards. Can you help us with who he was?
He was at this time, I think, the Chief Executive's Chief of Staff.
Within Post Office?
Within Post Office, I beg your pardon.
And if we scroll down to point 3, the briefing can address the issues we discussed yesterday, namely whether the Helen Rose report's in the public domain. No, it's not. And then I think it's sensible to keep references to the Helen Rose report to a minimum. In what context were you advising the Chief of Staff to keep any references to the Helen Rose report to a minimum?
I think in this you need to get that this is a document where the full trail, I think, is important and the context of what's happening. I think I'd been asked, if you go to the big, can I have the tab reference?
We'll give you the tab number 84, B84.
Oh, sorry, that's 184. So, so if you go all the way to the first...
Pages 4 and 5.
Yes, thank you.
If we look at the foot of page 4 and onto page 5, Mr. Edwards sends you some text for a report to the CEO on criminal cases.
Yes.
And the text is our criminal barrister, Brian Altman QC, has completed his review of the approach we're taking to reviewing cases that have been subject to prosecution, in particular at looking whether we're complying with our duty to disclose the findings of the second site report of the defence teams. His conclusion is that our approach is fundamentally sound, providing us with strong grounds to resist any formal review of our prosecutions, for example, by the CCRC. To date, following several sifts of our external firm solicitors, I identified 11 cases where disclosure is required. It's a matter for the defence to determine what action they might take. And then scroll up.
So to put that in context, to the best of my recollection is that I think that's in the, it's in the heading, it's a CEO report. So a report was prepared for the Chief Executive. I don't know to whom, I assume it's the board. It would be collected from various parts of the business on matters that had been were of interest to the board. I don't know what the criteria for that were. And then they would ask whoever was around to give either approval, sign off the writing. So I don't know where the draft started from on that. But he was saying, here's an extract for the CEO report, which as you can see is sort of relatively small, so very high level. What do you think? That's what I was asked to do. So I then, in the next one, I made some suggested amendments.
In the amended text we're looking at on the screen,
Yes.
you added in the words that are emboldened
Yeah.
and underlined.
Yep. That's right. I think, did I strike any out? Or it doesn't look like. Well, I think I replaced some words where it felt like we might be overreaching.
And then if we go to page 3, please.
It's at that point, my understanding was the documents being considered through the SIFT review for disclosure and past prosecutions was not just the second site report, but also the Helen Rose report. And so I introduced it in at this point saying, well, hang on, it's not just that document, there are two of them.
Mr. Edwards asks you at the foot of page 3, is the Helen Rose report a key part of the disclosure? If so, I think we'll need to include the reference to it in square brackets below. So is that him adding the text in that we've just looked at?
Sorry, who's that? So I'm sorry, what am I looking for in the highlighted section?
Mr. Edwards replied, is the Helen Rose report a key part of the disclosure? If so, I think we'll need to include the reference to it in square brackets below.
Mm-hmm.
So it looks like he's added those words in, and Helen Rose, in the text on page 4.
The text on page 4 now.
Yeah. I don't want to spend too long on this.
Oh, yeah, no, I'm sorry.
About the intricacies of drafting.
Yeah, I beg your pardon. No, I think I'd added it. It's not in the...
My only question was on page 1 of the email,
beg your pardon.
why did you want to keep references to the Helen Rose report to a minimum?
Or because I say this later on, it generated a lot of activity about what it was and what it involved.
Why did it generate activity about what it was and what it involved?
Well, we can see here Martin says, thanks. Unfortunately, I think I probably do need to give Paula more information on this. This is on page 2, as it's going to raise all sorts of questions from her and the board. Please, could you send me the report and any associated advice?
Yes.
So then I go, can we take some time to discuss?
Yes.
We agree. It's a quick... Martin says it's probably better not to mention the report specifically, as it will serve to confuse things.
Why would the mention of the report confuse things?
I don't know. I don't know.
And then we get to page 1.
Yep.
Where you say, I think it's sensible to keep references to the Helen Rose report to a minimum. And my question is, why did you think it's sensible to keep references to the Helen Rose report to a minimum?
So it was. So the way I'd read this, it was a question about what's being disclosed. The Helen Rose report was something that was being disclosed, and then the briefing note we'd received, which I think must have been from Cartwright King, I attach a briefing note, says it's unlikely to require disclosure in any further cases. So, in a short summary of matters, in a larger report on other things, as I understood it, it was something that didn't appear to be a live issue going forward.
Live issue for who?
For disclosure. And then, so it wasn't going to be something that was continuing to be disclosed. Actions weren't going to continue to be taken with respect to it, I think. And then I also added in that Brian's view was that it was added very little. So I'm sitting here thinking, I don't know if it doesn't seem to me to be particularly relevant going forward.
Thank you. Those are the only questions I asked today. So can we start at 9:45 a.m. tomorrow? I'll pick up questioning with the shredding advice.
Yeah, and tomorrow, Mr. Beer, we embark on a newish form, well, not newish, a new form of procedure, do we not? in that the representatives of core participants will be given a 45-minute time slot, and I think 3 have claimed it, to ask questions of Mr. Williams.
That's right, sir.
And I'm just telling everyone now that in my view, this will only work if people are scrupulous about using the time, because the last thing we want is for the third person of the core participants tomorrow afternoon being truncated because the 2 before him or her have overrun. So it's 45 minutes each, and I propose to be ruthless about it, just for everybody to know. Mr. Williams, overnight, I dare say you'll want to relax if you can, but you won't want to talk to anybody about your evidence, I'm sure. And I know you understand that you shouldn't.
I do,
so
sir.
thanks very much, and I'll see you all tomorrow.
Thanks, sir.
Thanks, sir.